Lagos, the Big Apple of Nigeria, and its commercial hub. Where business thrives, disputes arise. Those with no clue will opt to sue, but this doesn't have to be you.
Objection!
Whether a family matter or a business deal, information is power here on City Legal on Smooth 98.1. Brought to you by the Lagos Court of Arbitration. Good morning and welcome to yet another edition here on City Legal. And today, an interesting interview with Barrister Adebayo on ADR and real estate awaits on the show. The Lagos real estate market continues to benefit from the gains derived from a stable and progressive state government committed to improving the state infrastructure, rule of law, governance, and security. Lagos continues to remain an attractive destination for real estate investments in Nigeria and Africa based on both land and property appreciation and also in terms of achievable rental returns. Real estate investment continues to flow into the retail, residential, and office sector with ongoing developments in upmarket residential estates, development of modern shopping malls, and numerous new office developments in the pipeline. Lagos and Abuja have been listed among the top 4 cities in Africa with the highest cost of living, according to an index released by the Economist Intelligence Unit. The survey places Abuja as the second most expensive city in Africa, second only to Luanda, Angola, while Lagos comes fourth. The survey backs a recent report by Knight Frank, which identifies Luanda as having the most expensive commercial office space in Africa, beating Lagos to second place. Low-income housing continues to remain the elusive holy grail of the real estate residential market. The Nigerian mortgage market continues to remain at the bottom of the indices across Africa for mortgage penetration, with the attendant loss in associated economic benefits that would have been derived from a vibrant mortgage market. Federal and state governments are now aware that this is the segment of the market with the greatest need and the greatest potential positive impact on social improvements indices and have now stepped in with mortgage support plans that could provide a spark to kickstart growth in the market. We continue to watch closely plans being put in place by the federal and Lagos state government and finance institutions, including the Ministry of Finance and the Central Bank of Nigeria, with support from the World Bank. Meanwhile, developers continue to play their part by seeking to implement rapid build technology to bring down housing development costs. More on this on our interview on ADR and real estate. Do remember to log on to www.lagosarbitration.org. That's www.lagosarbitration.org for more information on how to be a member of the LCA, and follow the Lagos Court of Arbitration on Twitter at LCA_Lagos. Open the door to knowledge on the law. A little fact on ADR.
ADR provides a platform for informal and less confrontational means of dispute resolution. It avoids placing the label "wicked enemy" on the other party, but rather creates a friendly atmosphere for dispute resolution. The parties own the decision and therefore would be committed to maintaining it. A little fact on ADR.
City Legal, brought to you by the Lagos Court of Arbitration. And now, our interview with Barrister Adebayo on ADR and real estate.
Thank you for joining me here on City Legal on Smooth 98.1 FM. I'm at the law firm Adebayo and Adebayo, and I'm joined by Mr. Dayo Adebayo. He is a barrister and the managing partner of this firm. Now, he obtained his LLB from Obafemi Awolowo University back in 1990 and was called to the Nigerian bar in 1991. He did his internship with Gani Fawehinmi Chambers. He is a well-rounded lawyer who has attended various international seminars and trainings on different areas of law. He is a member of the Nigerian Bar Association, International Bar Association, and Chartered Institute of Arbitrators. He has authored several articles in various journals and publications, and he has over 22 years of experience in land and property matters and is an expert in the areas of recovery of premises, declaration of title, actions in trespass, and land disputes in relation to probate. Barrister Dayo Adebayo, thank you very much for joining us here on City Legal. You're most welcome.
Yeah, thank you.
Now, we're discussing real estate disputes and alternative dispute resolution. Now, real estate, Barrister, is big business, and in Lagos there have been a number of developments. Privately, individuals are benefiting also from purchases of land and creation of landlord and tenant relationships that generate handsome return, as well as other property transactions. Like, my question to you is, conflicts are a natural part of human interaction, and it is common amongst occupiers of land and buildings. Will you just give us some examples of disputes involving land or property, and what are the causes of these disputes?
Well, the issues that may arise are recovery of premises, declaration of title to land. We also have disputes arising from mortgage-related transactions. We have actions in trespass. Then we have probate actions, and these are actions that relate to testacy or intestacy in the case of a testator. Well, declaration to title to land, well, it's one of the very naughty areas of land disputes we have, and part of it is because the documentation is not thorough, whether with the government or with the private owners themselves. We have instances where you apply for certificate of occupancy for your land in Nigeria, and you find out that sometimes down the line you have another person with another certificate of occupancy on the same land. Then there is an issue. Who has the title to the land? Who is the proper owner of the land? Then we have the Omolile instances, where the Omoniles will lay claim, to a substantial part of land in Lagos or in some other places of the country. So then when it comes to recovery of premises, it's basically landlord and tenant issue, and for one reason or the other, there might be dispute between the landlord and the tenant. The disputes might arise out of violation of some clauses in the tenancy agreement. The tenant might have refused to pay rent, and any of these issues will lead to an action in court. We have probate issues and probate-related issues where you find siblings fighting for their father's estate. And they might also initiate actions in court as a result of that.
All right. In the situation where two people have been given a certificate of occupancy for the same piece of land, what would happen there? Who is the true owner in that sense?
Well, a certificate of occupancy, the courts have said, is not conclusive of ownership of the land. But what happens most times, that is, all things being equal, the first in time prevails. That is, the owner of the land with the first certificate of occupancy will probably have a better title to the land.
Now, in relation to alternative dispute resolution, how can ADR be used to resolve some of the disputes that you've just mentioned?
It's necessary to know that ADR has several facets. You have the arbitration, we have the conciliation, you have the negotiation, and the mediation. And any of these branches of ADR could be deployed effectively to resolving issues that relates to land and housing matters. For example, declaration to land. So many times it's just perception. Probably the area of the land might just be in dispute, but when you look at it critically, when you put in your survey, you might find out that the issues are narrowed down. They are not wide and apart. And by the time the parties sit down, and in the spirit of give and take, talking about negotiation now, that's where negotiation, and negotiation is basically dialogue between two or more people, with the intention of reaching an understanding, on a particular matter. So probably if the area is 20 acres, for instance, and by the time they sit down and they find out that, well, what is in contention between the two of them. When issues are narrowed down, when the survey have been done and in the land, might be about one plot, and that will take them several years in court. And out of 20 acres, the issue is just on one plot. Well, negotiation could be very useful here, in the spirit of give and take. Why not take half of it or 3/4 of it and let me take the other? And that will save them years. We've had cases last in court for 40 years in land matters. And it's time, because none of those parties will have access to that land, within that period. And what you find is that even the first generation of the litigants died in the process. The second generation take over, and the third. So of whose benefit, is this issue? So negotiation becomes very apt for resolving such type of issues.
All right. Thank you, Barrister. Indeed. Now, how can land disputes be avoided altogether?
Well, I don't believe land disputes can be avoided altogether, but we could really minimize the cases of land dispute. And the first one is we have to have a proper documentation of all land within every state. That is, if you point to a land, you could say who has the ownership of that land. But what happens here, especially virgin land, is that you can't, say particularly the ownership of that land. And when you go to check, because the Ministry of Lands and Survey, particularly in Lagos State, they have the survey, right? But the survey does not attach name to the land. Yeah, so you have the land, you can have this expanse of land, and this expanse probably can say it belongs to Ajayi family. But within Ajayi family, you might have several branches, about 10 branches. So you don't even know who to talk to within the Ajayi family. But if every land were to be demarcated and every house or property were to be properly identified, labeled, and titled, then you will know if I'm talking of this land or this house. I can make my search and I can discover who the owner of the property is. And another thing to talk about is the cost, of registering title is quite prohibitive, particularly in Lagos State. And what happens is people avoid documenting, their interest in land. And also, I think, we should have a very large database with the government, and the database should be open. And again, another issue is we need to change the manner in which a certificate of occupancy is printed. Because I think the way it is now, it's susceptible to forgery, and that's again another thing that we see. Then the deed of assignment, everybody now, we have all manner of deed of assignment. 5 lawyers prepare deed of assignment, 5 different formats of deed of assignment. If you are applying for a deed of assignment, what should come out from government should be one. So the people should be informed that, okay, a deed of assignment looks like this, and these are the contents of a deed of assignment, and these are the security features you should watch out for. And it will make life easier for both practitioners and for the citizens alike.
All right, Barrister. And finally, what are the advantages of using alternative dispute resolution in relation to land and property matters, and how can we move forward?
Well, ADR, it's the first advantage. It hits quick dispensation of justice. The average lifespan of a land matter, if it goes from the High Court to the Court of Appeal to the Supreme Court, you'll be looking at between 8 to 10 years. That's a lot. And we've had cases for 40 years they've been in courts, So ADR helps to get quick dispensation of justice, and it also promotes privacy and confidentiality. The documents are not open to pry eyes of the public. Then again, ADR doesn't have all those inbuilt technicalities, because that is one of the things that frustrates the quick dispensation of justice. You see, for one minute or one inconsequential reason, the lawyer will go on appeal, and to the Court of Appeal, then to the Supreme Court, and that is without the substance. Then you come back again to come with the substance. Then parties also have the opportunity to choose the arbitrators, and that's also another advantage. And litigation is quite expensive compared to arbitration. Finally, on that point, and very importantly too, parties live as friends. Well, how does it work? Or how can we improve? Or moving forward, what do we do? I think we need to train our lawyers to embrace arbitration. We need to talk to them for them to see the benefits of arbitration. Because the average lawyer thinks the longer he stays in court, the better for him. Probably in terms of remuneration, because he continues to bill his client for his time, and he doesn't know the same time he could have handled 4, 5 matters or 6 matters, which also will be, more cost-effective and more rewarding for him.
All right, Barrister, thank you very much for your time, and thank you for your extensive expertise in this area. Thank you so much.
Thank you. The pleasure is mine.
Legal term for the day. Contract. An enforceable oral or written agreement between 2 or more parties which creates an obligation to do or not to do a particular thing. Legal term for the day. Intestate. Dying without leaving a will, which means that the decedent's property passes to his or her beneficiaries according to statutory law. Legal term for the day.
Remember to visit www.lagosarbitration.org for more information on how to be a member of the LCA. For questions and feedback, do write info@lagosarbitration.org. That's info@lagosarbitration.org. City Legal, brought to you by the Lagos Court of Arbitration.